Welcome back. If you're looking for, well, a real crash course in high-stakes international justice, you've definitely come to the right place today. We're taking a deep dive into the reports surrounding a single, pretty devastating criminal case that's unfolding right now in Indonesia. It involves three Australian nationals, a fatal shooting inside a Bali villa, and the very severe legal possibility of capital punishment. Yeah, our mission today isn't really about chasing those sensational headlines. It's more about pulling apart the actual legal stuff, the procedures described in our sources. We need to understand not just what apparently happened in that villa, but importantly, what happens next when Australian citizens are accused under a legal code like Indonesia's, which can be, well, incredibly unforgiving.
Right. And the core tension here, the detail that makes this whole deep dive so sobering, really, is the charge itself. These three Australian suspects, they're formally facing charges of premeditated murder. And that's absolutely the top-tier offense under Indonesian law, specifically because it carries the maximum possible penalty there is, the death sentence.
Okay, let's unpack this then. We're talking about a situation where a popular holiday spot has suddenly become the backdrop for, potentially, a capital trial. So let's maybe kick things off with the facts of the incident itself, the one that set this whole legal machine rolling. The reports we've seen state this happened back in June.
That's right, back in June.
The victim was Zivan Radmanovic, a 32-year-old man from Melbourne. He was fatally shot, apparently in the bathroom of a rented property, Villa Casa Santisya.
Yeah, near Munggu Beach, which is in Bali's Badung district.
And the scene sounds like it was incredibly intense.
It certainly does, and the reports are quite clear this wasn't, just an isolated thing involving him. Radmanovic's partner, identified as Jazmyn, was reportedly right there in the villa and apparently hid under a blanket during the whole attack.
Wow.
And crucially, there's another person there too, a second Melbourne man, Sanar Ghanim, who's 34. He was also targeted in the attack, but he actually survived.
He survived.
Okay.
And the level of violence described by the investigators, just based on the evidence they collected, it seems to indicate a pretty determined effort, doesn't it?
Definitely. Police found a significant number of spent rounds.
Yeah, I saw that figure, 17 bullet casings.
17 casings, plus 2 intact bullets still at the scene. And witnesses cited in the report said 2 gunmen arrived around midnight together on a scooter.
17 casings. I mean, when you think about just the sheer number of projectiles fired, it paints a very different picture than, say, some kind of spontaneous fight, right?
Exactly. That detail alone, the 17 casings, it speaks volumes about, well, intent and determination, regardless of the motive, which, as we'll get into, is still officially sort of unclear.
Right. Okay, so now let's move into the investigation process itself, because this is where the international element really ramps up. The 3 men subsequently arrested are Darcy Jenson and Paea-I-Middlemore Tupou, both 27, and Coskun Mevlut, who's 22, all Australians.
Yeah, and the complexity of actually arresting them is a pretty big indicator of the priority the Bali police put on this case right from the start. The Bali Police Chief, Inspector General Daniel Aditya, he detailed the effort involved. One suspect was caught relatively quickly at a Jakarta airport just days after the shooting.
Okay.
But the other 2 had already managed to leave Indonesia entirely.
So they needed help getting them back.
Precisely. Securing their return required significant coordination through Interpol across Southeast Asia. And that kind of rapid, multi-jurisdictional chase really shows that authorities were throwing maximum effort at this from day one. They were determined.
You mentioned the structured nature of Indonesian investigations before, and there's one procedural step described in the sources that often seems quite, well, jarring to people used to common law systems like in Australia or the U.S. That's the forced reenactment.
Yes.
Apparently, back in July, these 3 men were made to reenact the alleged shooting. Why? Why is that step considered so critical in the Indonesian legal framework?
Well, what's fascinating here is that the reenactment, which can seem, quite dramatic and public, it actually serves a very specific legal purpose in their system. It's not like in many Western systems. Indonesian police often use this reenactment quite early on to sort of solidify the sequence of events of the alleged crime.
Solidify the sequence. How?
It basically forces the suspects, often along with any witnesses, to physically demonstrate their alleged actions step by step. This helps investigators lock down the timeline, the flow of events, before the case even moves to the prosecutor.
Okay.
It essentially tries to mitigate the possibility of the defense, say, dramatically changing the story or the sequels later on in court. It ensures the police's version of events is thoroughly documented and, importantly, visualized. contextualized.
So it's really a tool designed to reduce legal ambiguity later, to kind of stabilize the narrative of the crime before it even hits the trial phase.
Precisely. It helps transition the investigation from just gathering the physical evidence, like those bullet casings, to confirming the narrative structure that the prosecution is likely going to present in court.
Okay, that makes sense. So that structured investigation involving Interpol, this public reenactment has now led directly to the formal charges. And they are severe.
Yeah.
Public prosecutors in Bali have formally announced them. Premeditated murder against Radmanovic and attempted premeditated murder against Ghanim, the survivor.
And this is where we hit the absolute legal peak of this whole thing. The prosecutors didn't just go for standard murder charges. They specifically invoked Article 340 of Indonesia's criminal code. And if we connect this to the bigger picture, the entire legal strategy, the entire weight of the case now revolves around that single word, premeditated.
Okay, can you walk us through that distinction, specifically in the Indonesian context? What does it actually take to prove premeditation under Article 340, as opposed to, say, a standard murder charge?
Well, the difference is, frankly, existential for the accused. Standard murder, which falls under Article 338, still carries a very severe penalty up to 15 years in prison.
It's still very serious.
Absolutely. But Article 340 elevates the crime significantly because the law requires the prosecution to prove that the actual intent to kill existed before the act itself happened. This implies some period of prior reflection, maybe calculation or planning. Doesn't necessarily mean, weeks of intricate planning, but it has to be established that the accused had enough time to calmly consider the murder and then decided to go ahead anyway.
Calmly consider.
Yes, if the prosecution can prove that element of calm, calculating intent, then the maximum penalty is activated.
And that maximum penalty is, without any ambiguity, capital punishment.
Absolutely. The maximum penalty defined right there in Article 340 is the death sentence. Life imprisonment is the next option down. Now, for a country like Australia, which officially opposes the death penalty and has, historically engaged in pretty significant diplomatic efforts over past cases.
Yes, I remember some high-profile ones.
Exactly. So the invocation of Article 340 against its citizens immediately creates massive diplomatic stakes. The seriousness just cannot be overstated. This isn't some theoretical punishment in this jurisdiction. It happens.
So the entire legal fight moving forward, it won't necessarily hinge on if these men were involved in the shooting itself, but specifically on whether the prosecution can definitively prove that specific element, that calm, calculated intent required by Article 340.
That is the entire high-wire act of the upcoming trial. Yes, it shifts the focus from simple criminality, the act itself, to the mental state, the mens rea of the accused before the event even occurred.
Okay, so let's look at where things stand right now, the current status. The Badung police chief, M. Arif Batubara, stated that investigators have completed their case files and importantly declared them legally sufficient for prosecution. What does that specific phrase, legally sufficient, mean in terms of the process over there?
Right, so that generally refers to what they call the P21 stage, or the second phase of the process. Indonesian criminal cases typically move through phases. Phase 1 is the police investigation, gathering evidence. Phase 2, this P21 stage, is when the public prosecutor reviews that entire police file and formally determines that, yes, the evidence is complete enough, it's sufficient to actually proceed to trial.
Okay.
And when the prosecutor makes that declaration that the file is legally sufficient, they then officially take custody of both the physical evidence and, critically, the suspects themselves. This handover, the second phase, is crucial because it signals the end of the police's direct investigative authority over the case. It formally locks in the charges that the prosecutor now intends to pursue in court.
Okay, so here's where it gets really interesting then. The handover means the formal charging has happened, with all the weight of Article 340 attached. We know from that same police chief, Arif Batubara, that the suspects have apparently been cooperative throughout this initial investigation phase.
Yes, that was mentioned.
However, the prosecutor's office, in his public notice about this handover, left two pretty major unknowns just hanging there, didn't they?
They did.
They haven't actually specified the alleged motive for the murder, nor have they announced when any court proceedings might actually begin.
Yeah, and that silence on the motive, that's often a very deliberate legal strategy. While the police certainly would have developed theories, their whole investigation would likely be based on some theory of motive.
Sure.
The prosecutor might choose to withhold the official motive until the trial actually starts. By focusing publicly just on the act and that crucial premeditation element, they ensure that the public and media attention stays firmly fixed on the severity of the charges themselves, not on potentially, distracting or confusing details about whatever alleged dispute or debt might have supposedly triggered the attack.
So keep the focus tight on Article 340.
Essentially, yes. Keep the narrative clean and focused on the legal threshold for premeditation. So, wrapping this part up, the investigation phase is officially done, the charges are formalized under the most severe article, and the clock is basically ticking on a potential capital punishment trial, even though the public reason why remains, for now, blank.
Exactly. The administrative part of the process seems to be over, and now the legal and potentially political battle is about to begin. And I think the crucial takeaway here really is the speed and the severity with which the Indonesian authorities handled this entire case. They clearly didn't delay. They moved swiftly from the initial arrests through those procedural steps like the reenactments and straight into formal charges under the nation's absolute most severe penal code provision, Article 340.
So we've really journeyed from the initial reports of a shooting in a holiday villa through some complex international police work, right up to a formalized legal process that carries the explicit threat of capital punishment under Indonesian law. It really serves as a stark reminder of jurisdictional reality, doesn't it?
It does, and this raises an important question maybe for you, the listener, to consider. We know the evidence, like those 17 casings, definitely got the police's attention, right?
But the prosecution's entire case now, and ultimately the fate of these three men, it's going to rest almost entirely on proving that incredibly difficult element of premeditation. Yeah. And it's quite something to think about, isn't it? The fact that the ultimate legal difference between potentially a lifetime in prison and the death sentence, in this specific case, it hinges completely on the prosecution's ability to demonstrate that the suspects had maybe just one moment of prior calm reflection before pulling the trigger. It just underscores how fundamentally different legal systems can define and then prosecute the very highest levels of crime. That singular, almost philosophical distinction embedded right there in Article 340. That's the ultimate source of the incredibly high stakes for these accused Australians.